Bismillahirrahmanirrahim. Today we shall discuss center-province relations according to Constitution of 1956. This is lecture 3 of series 4. In previous lectures, lecture 1 was general characteristics of Constitution 1956. Second was Islamic provisions reflected in Constitution of 1956, and this is lecture 3rd of series 4, Center-Province Relations. So there are three aspects of this lecture: federal structure. There were 5 provinces: one East Pakistan, and West Pakistan was comprised by 4 provinces, tribal areas, and princely states were also there. Second is system which was adopted to run the federation, that was parliamentary political system was adopted. So distribution of powers. So administrative relations, financial relations, and there were legislative relations between federation and federating units. So a mechanism for smooth operation of the federation was adopted, and for the purpose various institutions were inducted in the Constitution. It is essential to discuss that this Constitution was comprised by 234 articles and 6 schedules. So as far as distribution of powers is concerned, Article 106, 108 and 109 were included in this Constitution. So distribution of power, Article 106, 108 and 109 reads as, so Article 106, center was allotted 30 items as far as 1935 Act is concerned, which was given by the British in the subcontinent in United India. So that was you can say 61 item, but in this there were only 30 items with the centers. Article 106, provinces were allotted 94 items, while in 1935 Act 55 items were transferred to the provinces. So in this way, some more provinces were given more powers and more department, more jurisdiction in this Constitution 1956. Article 106, so concurrent items were also included. There were 19 items. So in concurrent items, provinces were empowered to legislate. So however, the central government was also given power if the province or provinces and central government legislate on one item, so the central government's legislation will prevail. Article 109 is about the residuary powers. So as far as residuary powers were concerned, so according to these powers, Central government as well as federating units were given power to legislate in this. So this was a very loose type rather situation. Article 108, it was given power to make laws for implementing any treaty agreement. This power was given to the central government. According to this, the central government was empowered or entitled to legislate if there was any agreement uh, with the with any other state. So, financial relations. So, as far as finances are concerned, central government was more powerful, and flow of money was from center to the more amount was collected by the center and then transferred to the provincial government. According to 1956 constitution, so the center was given power to levy custom duties, export duties, excise duties, corporation tax, tax on income other than agriculture income, estate and succession duties in respect of property other than agricultural land, taxes on capital values of assets. So, at this time, it is pertinent to mention the most of the taxes were collected from the custom and excise duty. So, but now the situation a bit different. Provinces' sources were agriculture in taxes on agriculture income. So this is still everybody knows. So it is very difficult to impose and collect taxes on agriculture. So you can give argument in favor of it and against it. However, this is not the topic of the time. The capital value of agricultural land when the land was transferred, taxes on land on and buildings, taxes on mineral rights subject to the federal list, excise on alcohol and drugs taxes, on electricity taxes on vehicle, advertisement, animals, boats, professions, trade and luxury taxes. These were the provinces were empowered to impose and collect these taxes. As far as administrative relations are concerned, administrative relations between central and provinces were the federal government was vested with the ultimate responsibility of ensuring the peace and safety of the country. So this is a very vague statement through this. The central government was entitled or empowered to interfere in any province at any time. Article 126, a provincial government was obliged to exercise its executive authority in such a way as to ensure compliance with the acts of parliament and existing laws applying to that province. So concurrent list already discussed, the both were entitled. So another power which was criticized by the politicians at that time, that was Article 191, emergency provision. That was rather criticized by the politician. If the president was satisfied, Article 191 reads as, if the president was satisfied that the grave emergency existed in which the security of economic life of Pakistan or any part thereof was threatened by war or external aggression or by internal disturbance beyond the power of the provincial government to control, he could issue a proclamation of emergency, which might also be issued before the actual occurrence of war or any such aggression if the president was satisfied. So this power was criticized because the president was empowered to impose emergency at any time if he feels or if he is satisfied that this is going to happen as well. So this was considered against the, you can say, the powers against the autonomy of the provinces, because particularly East Pakistan was in favor of maximum provincial autonomy, while the leadership of the West Pakistan was in favor of the strong center. So it is obvious before Pakistan, when Qaeda Muhammad Ali Jinnah, when there was a movement, Pakistani Muslim leadership was demanding at that time more autonomy as well. So mechanism and institutions were provided for smooth operation or to address grievances, if any, in the between the provinces or between the province and the central government. The most important institution and the most powerful institution, that was judiciary. Independent judiciary having constitutional guarantees and powers were given in Constitution of 1956. So judiciary was there if there was any misunderstanding or any problem between the, so the judiciary was supposed to decide. So there was National Economic Council, National Finance Commission, the Inter-Provincial Council. However, it is very interesting, the nomination of the members of these councils was rather in power of the president on the advice of the prime minister. So this was the condition, or these were center province relations, or uh, you can say the distribution of powers between center and federating unit, federation and federating unit. So this is the lecture. This is the lecture 3 of series 4. Thank you very much.